This man faces decade behind bars for violent crimes. But today, the judge made a shocking decision. Will he get a second chance? Or is this the last lifeline he'll ever have? Stay tuned. This courtroom drama will leave you speechless.
Good morning. You're Trilen Jackson. And Mr. Jackson was previously in court, entered pleas of true to counts 1 through 5 in each of his motion to revoke unadjudicated probations. On probation for aggravated robbery, actually 3 cases. An aggravated robbery and then 2 aggravated assaults with deadly weapons. In cause numbers 24-1324, 1323, and 0883. I've received the updated pre-sentence report. This was unagreed, and has everyone had an opportunity to receive that report?
We have, Your Honor.
Are there any additions or corrections to that report? All right, Mr. Rojas, you may proceed.
Just, Mr. Jackson recognizes he's on probation for some serious offenses. And that, in my opinion, it's like he needs help. The main problem of the company, mental health issues, homelessness, he's got lack of transportation, and he's got limited families here in the area. Tells me that when he was first released from the jail, he didn't have a place to live, didn't have any transportation, not being able to get to probation partners at the beginning. He's been on probation for such a short period of time that he's been unable to get to the benefit of the resources that probation has caused him. I understand all that's because he's not extending probation. But again, I think that all comes from the homelessness and the lack of transportation and mental health issues. He is trying to get help for himself. He does have the application to the government benefit. He's got to contact with someone from MHMR if he were allowed to be allowed to stay on probation. Tells you that he has a place to live now. His cousin who does live here in Beaumont. He is hopeful that he can do the job that he's working for at the barbecue restaurant.
Good morning, everyone. Today, Trilen Jackson faces multiple serious charges, aggravated robbery and 2 aggravated assaults with deadly weapons. His probation was at risk due to prior violations. But as we dive deeper, you'll see this isn't just a legal story, it's a human story. Jackson has faced homelessness, transportation issues, and mental health challenges that prevented him from fully complying with probation requirements. Audience, think about this. How much responsibility falls on the individual versus the system?
Hold on.
And of course, that all is going to depend on him actually going through probation. And because he doesn't report to getting everything he can, make sure he does probation support what they'll allow to stay on probation. And that's what we asked him to do this morning, Judge. It's opportunity. He does have a place tonight.
Go ahead.
Hello, my name is Darren. I'm writing this letter pleading for mercy. I started my probation off on Friday. Everything I had on probation was in first place. I ended up losing cell phone and place that I was with. Found out that I was on probation and they kicked me out the house, and I didn't have, kicked me out. I kicked out the place. I was staying there. And the same night, the police came and arrested me for unpopular things that I didn't do. And they said I was under intoxication, but I wasn't. You know what I'm saying? It was all fighting and stuff like that. They took me in jail for one night for intoxication, but they didn't have no triple hours or nothing. Saying I was intoxicated and said I was intoxicated. It was wrong. It was wrong. And don't have any records of intoxications. Got to jail and released me the next day for public intoxication. I was reported the next day. The day I was supposed to report. You know how they get you out of jail. Like 3 o'clock. It was raining so bad. It was raining so bad. Yeah, I didn't have nowhere to get here. So
Jackson submitted a deeply personal letter to the court, describing lost housing, wrongful arrests, and life struggles. His plea was raw, emotional, and desperate for a second chance. This is where we see the human stakes. Someone's life hanging in the balance, and the courtroom acting as both judge and lifeline. Do you think the court should weigh compassion equally with punishment?
I walked. The next day I waited till it stopped raining. And it was unpleasant. And I walked to I walked to the probation office. And I told the lady I didn't have my social security card in my house. She was going to help me do it. I was really excited. Trying to get my GED. I was really trying to go to school. Yeah, the lady kicked me out of the house while I was staying. I had to move in the hotel, and I ran out of money, and bro, it all went downhill from here. Yeah. You can find any way for me to go get back on probation. I promise. I'm going to do the right thing. I'm a good citizen, help anybody I can. I'm a new Christian. Go to church, go to church, go to Christ. Yeah, man, I've been trying to stay out of trouble. You guys should bring up on over hard time, yeah.
Fluffy, no?
Well, they're not in this situation. I don't think it's something that is just coming in today saying that it's probably keeping them ongoing. People probably mentally wanted to give you the opportunity of probation so that you can participate in the mental health caseload. Obviously, very lucky to have her before, and the officers that I've spoken to her several times about this. She has gone above beyond just trying to make contact with them to bring him in and say, these are the resources we rather have to help you, and they just can't ever find them. I'm not suggesting that necessarily our position is revocation, but my position would be, Judge, if the court gives him this opportunity, he does not take advantage of it, and does not do what the court needs him to do, the court orders.
There's doesn't probably haven't even had enough time to know. I guess my question, Ms. Core, would be if
The judge recognized Jackson's challenges but emphasized accountability. Probation would continue, but only under the special needs track of safety, providing structured support for rehabilitation. The judge's warning was stark. Any future violations could result in decades in prison. Here, viewers, the drama peaks. This is what legal tension looks like in real life. Second chances are real but fleeting.
continue him on probation, would something like cognitive track of ISF be helpful, or that, or either special needs safety? Which one do you think would be more appropriate to help him get a good start for his life?
I would think that that is differentiate.
Okay. Okay. I mean, Mr. Jackson, everybody wants you to be successful, but you're the only one that can make that happen. You have all the resources. Ms. Core wants to help you. Probation has all kinds of things to help you, but they're not going to come. She's not going to come find you. So, if I give you this opportunity today, you're going to go get some help in custody. Listen, and when you're out though, and when you're finished with that treatment, it's going to be your responsibility to go where you're supposed to go, to let her know where you're living, and she's not going to go try to find you. You don't show up, then you're going to be back in here, and we will not be having these conversations. Today, I could send you to prison for the rest of your life for violating your probation. Right now, today. For life. 50 years, for 30 years, for 20 years. An aggravated robbery and 2 aggravated assaults with deadly weapons. You should probably be going to prison. So you need to understand that this is it. There's no second chance. This is your chance. All right? So I'm going to find that you entered your pleas of true to counts 1 through 5 in all 3 cases freely and voluntarily. find those counts true, find sufficient evidence in each case to revoke your probations and find you guilty, but I'm not going to do that. I'm going to continue your probations in each of your cases. I'm going to order in each of your cases that you enter and successfully complete the special needs track of safety. That's going to give you all kinds of help to make sure when you get out, you're ready to go and you'll be making better decisions. You won't have any issues, hopefully, with regard to any type of drug or alcohol abuse, and you will also have aftercare, a place to live, and things like that. So you're going to have what you need, and it's going to be up to you. All right. Good luck to you, sir. You can go back with the bailiff. Thank you, sure. All right. This is cause number 1830854, and sir, you're Juan Sanchez. And so we're here today on a motion to compel, and before we get into a whole lot, I've done a lot of my own research and looking at all of this, and a couple of things. One,
the courtroom turned to legal procedure, motion to compel, and subpoenas dutes tecum. The judge clarified what records are discoverable and how the defense must request them properly. This may seem technical, but it's crucial. These rules protect both the defendant and the integrity of the legal system. Ever wonder how much behind-the-scenes paperwork affects outcomes in high-stakes cases?
one, I don't believe the subpoena dutes tecum was the proper way to try to get information. Dutes tecum is an order that somebody brings something to a set hearing. So, but we didn't have a set hearing, and they weren't ordered to give it to it at a set time for a hearing. So, under the rules that have to do with subpoena dutes tecum, I don't know that that was the proper way. I do think you're entitled to some of that information as a defense attorney. If we're going to base decisions on, if I'm going to base decisions on things that probation have in their file and that they're just going to tell us, I do believe that you are entitled to some of that information. I think the proper way to do it would be to make that request to the attorney's office for discovery. And then for you, Mr. Nichols, to make those requests. And then I would prove you guys giving whatever records are requested within reason. If you have, I don't know what would necessarily be any type of work product that would not be discoverable, but if you think that there's something that is particularly not discoverable, let Mr. Nichols know that. Mr. Nichols let me know that. Then we could worry about maybe a motion to compel and whether or not I think those things are or aren't. But lab results, testing, money owed, all of those types of things, I think, are probably discoverable and something that Mrs. Winkler needs. I just don't think this was the...
I agree, Judge. Many of the things that came, well, I do think it's discoverable. In this case, it's all allegations on the motion based on arrest out of county. And so, his offense record, I don't know why it's in the entire probation file when it's not even part of the allegation. So, may I respond, Your Honor?
Well, let him finish, yes.
He did subpoena Wharton County records, so originally from probation that have came in today for this, and I have no problem giving them all that stuff. A lot of it's not in my possession. The out of county office report and things like that. I don't have it. I would have that towards the hearing where I prove up those allegations in that court. I don't have it. Again, I don't have all that stuff. So
Sure.
So, directly to the agency properly. And Mr. Pringle did make a standard discovery request at the onset of involvement with his early arrest.
Right.
Or having anything really responsive to him.
Okay. So obviously, if it's based on a new offense out of another county, that's something you'll need to work.
Jackson was given a lifeline with structured probation, counseling, and housing support. This case highlights the balance between justice and rehabilitation, showing the human side of the law. It's a reminder that courtrooms aren't just about punishment. They're about second chances, responsibility, and systemic support. Audience question: if you were in Jackson's shoes, would you seize this opportunity or risk it all again?